Hello, welcome to the final part or installment of our video lecture series for module 4 C. Now, for the last part, we shall be discussing retention rights under RA 6657. As we said in the previous video, uh, acquisition of land holdings, covered land holdings under RA 6657 will have adverse effects towards the landowners because the landowners will be deprived of their properties against their will. Of course, even if there is just compensation, still uh, the adverse effects of this forcible taking uh, are still present. So, in order to mitigate the adverse effects, in order to grant also benefits to balance the interests of the parties concerned, no? The law also provides retention rights. No, PD 27 also provides retention rights, but RA 6657 na asa siya retention rights with its own framework, applicable rules, and of course jurisprudence. Now we shall discuss here these things. Just to present to you the verbatim nga portion under RA 6657 section 6 niingon dire that in no case shall retention by the landowner exceed 5 hectares. That means the maximum retention limit here under RA 6657 would be 5 hectares. Okay? PD 27 7 hectares ba? Okay? Here 5 hectares, but that's not all because under the law it further states nga there will be additional 3 hectares, okay, which may be awarded to each child of the landowner. No, the landowner, okay, may be able to retain more than 5 hectares provided na he has a child, okay, and the child is at least 15 years of age, and that he or she is actually tilling the land or directly managing the farm, right? That means if a child, even though, diba, child siya sa offspring siya sa landowner, if a child is not at least 15 years of age, all right? Or he, even if 15 years of age siya, pero basin not actually tilling the land or not directly managing the farm, then the landowner will not be entitled to additional 3 hectares. But if these two qualifications are present in let's say 4 children, then 3 hectares per child will be allowed to be retained by the landowner in addition to the original 5 hectares. All right. The hope here is clear. First, in order for the loophole, for the vagueness in PD 27 to be addressed, because the criteria for retention in the PD 27 somehow vague, and it was open for interpretation, in fact used for oppressive interpretation. All right. And second here, in order to afford the landowner, in order to afford the opportunity, afford the landowner the opportunity to retain a specific amount or a specific area of his or her land holdings, which would be sufficient not just for himself but also for his family. And when the time he or she is gone, there will be some portions which will be left for succession, which will be left for hereditary succession. Right? The problem ang good, if 5 hectares lang and then there are so many children, the children will clearly be uh, you know disadvantaged uh, in such a case. All right, but if you allow some form of flexibility here, like this, each child would be given 3 hectares, provided of course na qualifications. then that would mean there will be ample portions of the land holdings which may be subject of hereditary succession when the original landowner uh, will pass away. All right. So that's the CODA provision. Right. Now let's go to the character of retention rights. Now, unlike retention rights under PD 27, retention rights now under RA 6657 are considered as constitutionally guaranteed. Okay, constitutionally guaranteed, that means the Constitution itself recognizes that retention rights should exist. Retention rights exist under our framework. No? But what the Constitution does not do is to specify, no, what up to what area can a landowner retain. In fact, the Constitution leaves this for determination by Congress. In fact, the 5 hectares plus 3 hectares under RA 6657 is the exercise of that prerogative granted to Congress by the Constitution. So it's constitutionally guaranteed, but the area, the specifics will have to be legislatively determined. All right? Now, just like the retention rights under PD 27, however, the purpose is to balance the effects of compulsory acquisition because na yung mga adverse effects, to balance the rights and interests of the parties, to mitigate in even the compulsory and the effects of the compulsory acquisition. So naa ni siyang retention rights. But again, retention rights, it's a right, and under our framework, it's a waivable right, meaning it may be waived depending on the circumstances identified. All right. Note that retention is not equal to exemption. No? If retention, it presupposes even that your land is covered, but specific areas of the covered lands retained siya by the landowner. Okay? While exemption or exclusion, all throughout, I mean, the whole land, because it is not perhaps not identified as included or identified siya as exempted, identified siya as excluded, then the entire area, no, outside siya of the scope of the law. Right? Now, retention rights. Now, when do we exercise retention rights? Now, because as we said, retention rights waivable. So we have to know when should we exercise it if you're a landowner. Now, depends if it's a voluntary mode of acquisition or compulsory mode of acquisition. Remember, only one kind of voluntary na karon, no? Ang voluntary land transfer not anymore allowed. So voluntary offer for sale, the retention rights are exercised simultaneously with the offer for sale. No, when you offer, of course, you offer only the portions which you do not intend to retain. So you don't offer the area which you intend to retain. Okay, that simultaneously, therefore, that's an exercise, or that's when you express your intention to retain that portion simultaneously with that offer. But if compulsory acquisition is it's either at any time before the notice of coverage, so meaning even if you did not get a notice of coverage yet, but you think that this is an agricultural land that is covered by RA 6657, then you may go to the DAR and ask or apply for retention even if there's no notice of coverage yet. But of course, you don't do that perhaps you want to wait for the DAR to conclude that your land is covered, and in such a case you will wait for the notice of coverage. All right. If there is already a notice of coverage, the rule states that a landowner issued with a notice of coverage will have a period of 60 days no? 2 months from receipt thereof within which to exercise retention rights. All right? Very important na unya ang period because as I said, this failure to exercise retention rights within that periods identified will be considered as a waiver under the rules. Right? Now, who can exercise retention rights? Who can exercise retention rights under the rules? Of course, landowner ka, covered under RA 6657, then you can exercise retention rights. Diba? Basic. But landowners, na po yung mga landowners nga diverse ilang portfolio, diverse ilang land holding such that when PD 27 took effect, they had rice and corn lands. They also had agricultural lands nga not devoted primarily to corn and lands. No? Upon effectivity of PD 27, okay, covered ang portion lang sa ilang land holdings, but they own some other kinds of lands, some other mga lands in other places which are not covered by PD 27, no? Not corn land, not rice land. Okay? But under RA 6657, if na agricultural activity, agricultural land, not classified as mineral, etc., then that's covered. All right? In which case, kaning a landowner whose land was previously covered by PD 27 is now covered under RA 6657 insofar as his other lands are concerned. Right? But no, that kind of landowner may exercise retention rights. Now, in all cases, so meaning na siya 7 hectares plus 5 hectares pag yun under 6657 plus 3 plus 3 plus 3 depending on the number of children who qualify. No? Is that the case? Fortunately, not. All right? This was actually the discussion in the case of J. Melissa Estate Development Incorporated versus Simoy in 2016. Okay? The court here identified na, okay, as a general rule, if you're a landowner who has availed of retention rights under PD 27, disqualified na ka from availing of additional nga retention rights under RA 6657 on the same land. Okay? For example, ni-retain na kag 7 hectares and then you want more 5 hectares in that same land after naka-retain ka, not anymore, no? Basically, in reality, you can't anymore avail because more likely than not, the rest of the portion have already been redistributed under PD 27, and therefore you cannot anymore avail of RA 665. I mean, the retention rights under RA 6657 on the same land. But in case you have other lands which were not covered by PD 27, okay, and are now covered by RA 6657, you may, landowner, you may exercise retention rights under RA 6657 on those other lands. But, caveat, it is not in addition to the original 7 hectares. No, di siya addition. Okay? It's in lieu of the previously retained land under PD 27. Because the effect here is that if the landowner whose land was covered under PD 27 and who has already exercised retention rights thereunder will exercise retention rights under 6657 in other ng mga land holdings niya, then the land previously retained under PD 27 will be subject to compulsory acquisition, will be covered na siya under RA 6657. No, it's like this one. For example, no, here you have rice or corn 7 hectares man ang imuhang gi-retain because that's the maximum under PD 27. So that's retained under PD 27. But you also own a land, okay, a tobacco farm. Now, because there's agricultural activity there, it's covered under RA 6657. It's also 7 hectares, right? It's covered under 6657. Now, because you as the landowner has a land holding that is now covered under 6657, you may exercise retention rights here. Okay? But the consequence for exercising retention rights under RA 6657 in this area is that you forfeit the previously retained area. Okay? Such that the previously retained area nga 7 hectares will now be covered under covered under RA 6657 while you retain 5 hectares, okay, in the tobacco farm, okay, and the excess of 5 hectares provided here na wala siya anak, wala siya child, no? The excess would be here covered also by RA 6657. All right? Okay, that's the effect of availing of RA's of retention rights under RA 6657 if you have previously retained under PD 27. It's not in addition to, but it's in lieu of the previously covered, meaning you forfeit your previously retained land under PD 27. All right? Now, rule of thumb in retention rights. As a requirement, lands that are retained through retention rights must be compact or contiguous, meaning it must not be murag chop. All right? Take for example this case, no? This set of facts. Now here we have a whole land holding. Let's just say, muna siya usa ka land holding which is covered under RA 6657. Now, somehow the soil, the fertility of the soil in this land is uneven. Let's just say, no? Uneven siya. Such that here, very fertile ang soil, but the expanse would be just 3 hectares. And then after the 3 hectares, mahimo ng not so fertile, not so ideal nga area. And then afterwards, na ay portion at the very end sa land holding niya, mga 2 hectares fertile area na siya. Not as fertile as the first one, okay, but better than the middle one. All right? In this scenario, therefore, no, kailangan siya compact and contiguous, and therefore the landowner cannot do this. Okay? The brown boxes signify the option of the landowner to retain. Okay? Because he knows, the landowner knows nga, uy, very fertile dire, and here not so fertile, and then here it's okay lang fertile. Okay, since I am allowed 5 hectares, okay, I will retain this part, no, very fertile, 3 hectares, and I will retain this part, no, fertile area, and 2 hectares, 5 hectares, no, solve. And then what will be redistributed would be the not so fertile area, right? Had the requirement of compact and contiguous not been inserted, not been incorporated in the law, this can perfectly happen. Okay, but thankfully, because of this requirement under the law, this is not allowed. What the landowner should do is to retain, if he or she wants really the very fertile soil, a portion, has to retain that, and then in addition to that, he or she should retain that area nga na ay not so fertile area, such that ang ma-redistribute would be at least a part lang sa not so fertile area and this fertile area. Alright? That's just an illustration, ha? This factual circumstance is just an illustration Okay? Illustration na siya as to what would be the considerations why some persons, some landowners would prefer nga dili siya compact or contiguous, no? In such a case, we can illustrate na, uy, yes, there may be a case where he knows or she knows na this area, which is in the middle, not so fertile area, and therefore, di ba, mo chop-chop ang iyahang retention. Alright? But that's not allowed because under the law, it should be the retained land retained should be compact and contiguous. Alright? Now, as we said, retention rights, it may be waived. Right? Pwede siya ma-waive. And how will retention rights be waived? Right? Retention rights may be waived by firstly failure to timely manifest the intention to retain, no? Unsa nang mga time limit for manifestation of intention to retain, di ba? Depende if voluntary or compulsory, because if voluntary, it should be simultaneous with the offer for sale, while if compulsory, it may be at any time before the notice of coverage is received or within 60 days from receipt of the notice of coverage. Beyond that will be considered as a failure to timely manifest intention to retain, and therefore the retention rights will be considered as to have waived, no? Waived na siya. All right? Also, self-explanatory, if you sign something unequivocally and expressly waiving your rights of retention, then of course your retention rights will be considered as waived. Lastly, according to the rules, retention rights may also be waived by estoppel by laches, which will warrant the presumption that he abandoned his right. Alright? In such cases, therefore, retention rights may be waived. Note that homestead grantees under kaning Commonwealth Act number 141, in your land titles, perhaps you learned grantees who were identified as beneficiaries under CA 141 were given mga homestead patents, and on the basis of the homestead patents, they were issued mga original certificates of title. All right, meaning they were given lands, essentially they were given lands by the state. All right, not for the purpose of agrarian reform, huh? It's for some other purpose, but still somehow social legislation, social or like social justice happen, because it's for the welfare of the poor who can't afford lands for their homes. So they were given parcels of lands on which they can build and build their homes. That's why it's called homestead patent. Okay. But then a question arises, because they were subject of homestead grants, homestead patents. They were given lands substantial ang area, but then some of them remain to be some of the lands remain to be agricultural, and di ba, agricultural lands provided nga napa devoted to agriculture and then not classified as otherwise, then covered siya under RA 6657. Now, just in case a homestead grant, no, covered siya by RA 6657, will the homestead grantees be allowed to exercise retention rights? That's a question in Alita versus Court of Appeals in 1989. According to the court, yes, homestead grantees, insofar as they are also landowners, they may exercise retention rights. No? This is because the provisions of Commonwealth Act number 141 was for the protection of the welfare of the poor. Okay, to give the poor some kind of benefit under the law, no, to give them the necessary tools in the form of land holding to establish their homes, they establish their living. All right. Uh, and because that's the thrust of CA 141, especially that portion granting homestead patent, uh, agrarian reform, which is also a social legislation, meaning there's di ba equal na social legislation, cannot defeat the purpose of Commonwealth Act number 141. And if it cannot defeat the purpose of Commonwealth Act number 141, then it necessarily follows that homestead patent grantees uh, enjoy the same rights as landowners who are covered by RA 6657, and therefore they may exercise retention rights. But in the case of Almiro versus heirs of Paking in 2014, this is qualified, no, to be na yes, homestead patent grantees, you have a right to retention, but only when the following conditions exist. Number one, the original homestead owners or grantees are still the owners at the time of the effectivity of the CARL. Okay? At the time of the effectivity of the CARL, they are still the owners and they continue to cultivate the homestead land for themselves. Then they are entitled. No? They are entitled to retention rights. If these following conditions do not exist, then even though homestead grantee ka, homestead patent grantee ka, you are not allowed, you are not afforded with uh, uh, with retention rights. All right, that's the end of our module 4-C video lecture series. The next discussion would be on land redistribution under CARL or under RA 6657. There we will discuss the rules on the identification of beneficiaries, the maximum allowable award to beneficiaries, and such other na mga pertinent discussions on land redistribution. Thank you for listening. Thank you for being with me in this asynchronous video lecture series for all the 4 parts. And see you in the next module. Okay, thank you and God